Alina Sholtsova. I'm an immigration attorney from New York. In today's live video, we will be discussing the most recent immigration news, a memo issued to prosecutors in immigration court and judges. It's about prosecutorial discretion and how the judges should adjudicate requests to dismiss or administratively close cases, who is and who is not an enforcement priority. And it sheds light on the question of why so many cases are pending for forever and what's going to happen and how the courts are going to approach this massive amount of cases together with prosecutors trying to resolve the tremendous backlog. So if this is your first time here, welcome. My name is Alina Sholtsova. I'm a practicing attorney from New York, but I do help people in all 50 states and overseas. I help people with various issues of immigration law and represent them in removal proceedings as well. We also help with international cases such as waivers when somebody is stuck overseas or does not know how to come back after deportation. So if you have any immigration questions, issues, worries, please make an appointment. I'll be happy to try to assist you. My number is 917-885-2261. And here I'm going to share with you news and my thoughts on the memo that was issued, and then I will answer your guys' questions. So thank you very much for joining. Do not forget to like and share this stream, and also let me know where you're watching from. And let's start. So September 28th, we have this new memo as a result of court litigation, most likely, issued that covers various aspects of work of immigration judges. And specifically, it talks about who is a priority, enforcement priority for immigration, and which cases should be resolved in court first. I know that many of you are waiting for your court hearings in court, and some of you are getting frustrated. You would like your hearing to take place sooner than later, preferably sooner, and you do not understand why you do not have a hearing date. Well, most likely it's because prosecutor determined that you're not an enforcement priority. The memo explains here that it's OPLA, or prosecutor in your immigration case, who decides whether or not your case is an enforcement priority. Just like memos before this one, the memo says that somebody who presents threat to national security or public safety due to serious criminal conduct or to border security would be an enforcement priority, and that person's case would have to go forward. Border security threat would be someone who enters the United States and gets apprehended, enters unlawfully after November 1st, 2020. So relatively recent entry, or attempts to enter the United States after November 1st, 2020, and is apprehended at the border. You may know that these people sometimes are subject to super fast expedited removal proceedings. And that's why, basically because they are an enforcement priority, and the prosecutors and judges have memos that are basically directives that these people should be removed as soon as possible. And then the memo explains what happens to the rest of us, right? What if you did not commit any crime and you're just a person seeking asylum? Well, it says that to curb the backlog, prosecutors have wide ability to exercise their prosecutorial discretion and determine what is it they want to do with the case. Their preferred method to dispose of a case would be dismissal. Dismissal is when your case is closed in court, terminated, very often with the phrase without prejudice, meaning that it can be reopened at some point later, usually if you do something new. Many of you who recently ended up in removal proceedings may face this situation where a judge or the prosecutor offers for your case to be terminated, okay, or dismissed. But then you have to know that if you choose this option, potentially, and it depends on your situation, you may not be able to qualify for any future relief. And if you had a work permit based on a pending in court application, it will be terminated. So this memo says that the judges should listen or take into consideration objections of the parties, but they still may rule the way they feel is the right way to rule in a particular case. In other words, if a prosecutor comes to court and says, Judge, we would like this case to be dismissed, they make a motion, application for the case to be dismissed, then the court would ask you, the person who is in removal proceedings, well, what do you think? What do you want to do? If you would like to move forward with the case, most likely the court will move forward with the case, because in the same memo, it says that those cases that are enforcement priority or where the respondent would like to have a full hearing should move forward. So if you do not make your objection, the case will be dismissed. If you make your objection, the case most likely is going to go forward. But it's not the only way the case can be dealt with in court apart from the trial. The judge also may administratively close your case. And here, according to this memo, they don't necessarily have to listen to you, because it says that if the court determines that the best way to deal with the case would be an administrative closure, an objection by a party is not controlling. It means that, for example, the court says, or the party says, the prosecutor says, we would like to have the case taken off active calendar. It means that you're not going to have the date and nothing active is going to be happening in your case, but you will be technically left in removal proceedings, and usually you will be allowed to keep your work permit. But you say, well, but I think that I would like to go to trial. However, I'm not ready yet because something happens. Usually something else is pending with USCIS. So here the court may say, well, we understand your wish, but the thing is this, usually, because we do not know when something else that you're waiting for is going to be granted or denied, resolved, we think the best way to handle it would be administrative closure, putting your case on the shelf. In other words, the judges most likely will listen to you if they decide whether or not to dismiss the case, and do not have to listen to you when they decide whether or not to administratively close the case. Very interesting memo. Helps you to prepare for your court hearings, gives you good points if you would like to move your case faster in court, or maybe you don't want to move your case faster in court. And again, it depends on your goals, on your preparation and strengths of your case. So again, issued on September 28th, just a couple of days ago. And if you are in immigration court, you should know about this memo, and your attorney should know about this too. And now, guys, if you have questions, I'll be happy to answer them. Hi, Harry. Hi, Hack. What about domestic renewal for H-1B start date? I don't have a date for that. I know that Department of State did say that they will be renewing H-1Bs in the United States, just like they did, I believe, before 9/11, but do not have any specific date to advise you about. Hi, Mohammed. Can religious worker change the employer while I-45 is pending for 18 months? Please let me know. I wouldn't be able to let you know, unfortunately. Well, generally speaking, in I-140 case, this is the case that's filed by everybody else, not religious workers. It's possible to to change employers. But in your particular case, what happens is that a religious worker can file I-45 only after I-360 is approved, all right? So if you would like to change your employer, most likely you would have to have a new I-360 approved. That would be the logic that I would be using to answer your question. But if you would like me to do some research and make sure that this is the case, please come for a consultation. I'll be very happy to help you out. You can also inquire with your attorney. But because of the structure of the religious employment case, because if it was truly religious employment, it means that you had I-360 approved rather than I-140. I think you are out of luck here. But again, maybe there is some exceptions that I just never dealt with. Hi, True Wisdom. Hi, Elena. Do you think the processing time will change at all? And I'm waiting for my I-130 from December 2022 through my US citizen daughter. I'm out of the country. Your I-130 was supposed to have been approved by now because it's a parent type of a case unless you had issues, immigration issues. Let's say you were in the United States before, or maybe somebody else tried filing you like a spouse, you were accused of some sort of a marriage fraud situation. Parents, I-130s or I-130s for parents get approved very fast. But what happens afterwards? You have to go through consular processing, and that may take time, all right? That may take time because what happens with I-130 consular processing is that first I-130 is approved, then the case is moved to National Visa Center. Then you have to give documents again to National Visa Center, and then you have to wait for your interview. So not only you have to go through this processing times related to the petition itself, then you're going to get stuck on the consular processing. And for that reason, it takes some time, longer than usual processing times for I-130, which would be 9 to 10 months. My recent I-130 for parents were approved 3 to 5 months, very fast, okay? So make sure that it's either still pending or maybe there is a request for more evidence and so on and so forth. Hi, Alex. I'm looking for an attorney that is dealing with EB3 visas, and I'm interested in the price for those visas. Guys, I have a Russian TikTok for those who speak Russian, Alex does, and Russian YouTube. And today I published a video. I think, Alex, you asked this question before, if I'm not mistaken, through the YouTube, or how much a case like this may cost and so on and so forth. So what happens with the EB3 cases is that it's an employer who should hire an attorney, because employer, the company, will be the client of that attorney. On behalf of the company, attorney will have to handle the labor certification process, file I-140 petition, and potentially answer any requests for more evidence and so on and so forth. Cases like that require a lot of work, hence the fees are going to be high, usually paid again by the employer. The fees range from $10,000 to $25,000, $30,000, depending on the case, okay? But again, that's an employer who usually hires, not the employee. Hi, Ram, watching from New Jersey. Nice to see you. All right. Hi, Farouk. My I-360 has approved within 3 months with a deferred action. If I file work permit now, when I can get my decision? Somebody told me that if I have deferred action, I should be very fast. Your I-360, I assume, based on special immigrant juvenile status, right? And then you're allowed to file for the work permit. How long that work permit is going to be pending, again, cannot tell you. The problem is that different work permits in different categories are pending for various amount of time. The fastest work permit would be issued to somebody who filed for asylum, and this is their first work permit. Within 30 days, usually maximum 45, you will have that work permit in your hand. I-360 work permits, I'm not sure, but recently the government stated that generally speaking, they would like to have work permits usually issued within 90 days. All right. So if they're going to stay true to their word, I would say no later than 3 months, you should get your work permit. All right. Hi, Anil. Hi, Sajid. Unfortunately, I'm not dealing with Canadian immigration, guys. Many of you are asking this question, but I'm licensed only in the United States, and I cannot help you to immigrate to Canada. But I'm sure with some research, you can find very talented Canadian immigration consultants. Hi, McCrane. Hello. For marriage-based green card, can I start filing for all of the forms, or should I wait after the ceremony? You should definitely wait to get officially married. For the marriage-based case, you cannot submit it before you guys have that marriage certificate. Prove that you actually did get legally married. And before you get legally married, make sure you're not married to anyone else. Meaning that if you were previously married, you have to obtain divorce, official divorce from all previous marriages that you had. Some people believe, for some reason, that when they file marriage-based case, they only have to show that they're divorced from their last spouse. This is not the case. If you had multiple marriages previously, USCIS will demand that you produce divorce certificates from each and every marriage you had in the past. Just remember that. And they have to be true divorce certificates. Some people get into trouble because they're producing a fake divorce certificate. I do not know what exactly moves a person to do that. Maybe because it's difficult for them to get officially divorced from their previous spouse, but USCIS officers are trained very well to spot those. Because, guys, they have examples from previous filers and they know how real certificates should look like and how to check with the official government representatives from the countries this official records are coming from, whether or not the documents are real. So invest some time, make sure you are free to marry before you start the marriage-based case, and you do have to get married first. Hi, Neraldine. My removal proceedings were dismissed after having filed asylum with USCIS. Does it mean my asylum is affirmative now? I don't think so. Here what happens. I mean, let's say you file your USCIS asylum. You filed your asylum with USCIS because you were placed in removal proceedings, but you did not have the date, right? You were issued notice to appear, but didn't have a date. So what happens afterwards is that once you have a date in court, USCIS technically no longer has jurisdiction over your asylum case, and it should automatically terminate with USCIS. And usually they do it pretty quickly. Then you go to court, and for some reason you want the case in court to be terminated. Now, I do not know if you attempted to refile your asylum claim with court, which you should have, all right, prior to termination. But if not, you may find yourself in a situation when in reality nothing else anywhere is pending. And I think legally that's exactly what should happen. I'm yet to hear from USCIS, not lawyers, not clients, as to how they will be dealing with this particular situation, all right? But I think they're going to tell you to refile your case with USCIS, and you potentially have to address the issue of 1 year filing deadline, which you should probably be covered by an exception if you're going to be too late refiling your case after 1 year passes from your entry. But I think that's what should happen. I do not believe that you will be automatically considered back in administrative administrative, affirmative rather, asylum process. Okay, that's what I think. You can ask some other lawyers. I actually participated in discussions with other lawyers about this, and you know, basically, I think that's what should happen. But again, not to make a mistake here, USCIS should tell people what and how they want them to handle this situation, because this situation is not covered by any book. It was not supposed to have happened to you at all. If somebody was issued a notice to appear, they were supposed to have an opportunity to file their case and be processed with the court. But because of this huge backlogs, it didn't happen, right? You had to submit your case to USCIS not to miss the deadline. Then you were bounced back to court. Now the court wants to dismiss your case. And I'm of an opinion that when that happens, a person is left without status. Okay? And if you want to get your status, you have to refile your case. I may be wrong, but I don't think so, unfortunately, because I did see those dismissals by USCIS. Yeah. Hi, Mr. Penna. Can I become a citizen with a felony? With a felony? Well, it depends, I would say. A felony, what happened? Where was the felony committed? Did you plead guilty or did you face a trial? Was it related to controlled substance? Is it an aggravated felony? If it's an aggravated felony, then no, that's for sure. If it's not an aggravated felony, maybe you can address it somehow. And there are various ways to go about that. So I wouldn't know, okay? It depends. If you are thinking about citizenship, were you able to keep your green card? Because usually if you have a felony and you just have a green card, the government will try to deport you. Did you go through the removal proceedings, filed for the waiver, cancellation of removal? What happened? So I do not know, you know. You will need to take certificate of disposition and minutes of guilty plea and show those documents to an immigration attorney, and they will sit down with you and see if you have any hope of becoming a US citizen if you are a green card holder, okay? And I'm going to take the last question for today, guys. I have a pending M-30 petition, concurrently filed adjustment of status 3 months ago. How long do I have to wait until I get a decision from USCIS? I have done biometrics. It depends. So I-130 means that a relative filed for you, hopefully a spouse. If you guys submitted a strong marriage-based case and you do not have any other issues in your case, previous unsuccessful filings, maybe allegations of inadmissibility, if everything goes well, hopefully in 3 more months about, you should get your green card without the interview, okay? If everything goes well. It also sometimes depends on the jurisdiction, all right? In New York, it may take a little bit longer than 6 months. It may take 8 to 9 months to go through this process, but again, most likely without an interview, if you submitted sufficient evidence to prove that you are admissible and you have a real marriage. So thank you very much, guys, for watching. It was a pleasure to see all of you here. Hopefully, we're going to see each other next week as well. Do not forget to sign up for my YouTube channel and join our Facebook page, follow and like it, and I hope to see you soon.